Good afternoon and a very warm welcome to everyone who is joining us today. My name is Ekaterina Aristova. I'm a research fellow at the Bonavero Institute of Human Rights, and it's a great pleasure to welcome you and to moderate today's launch of the report, latest report in the Bonavero Report series, entitled International Human Rights Obligations in Relation to Climate Change, written by Professor Martin Scheinin. This report reproduces Professor Scheinin's expert submission to the International Court of Justice, prepared at the invitation of the Republic of Vanuatu in the context of the ongoing request for the advisory opinion on the obligations of states in respect to climate change, expected later this year. The report examines how international human rights law frames states' obligations in the face of climate change, and also the consequences of their failure to meet these obligations for a wider groups, including states, peoples, individuals, and importantly, future generations as well. Professor Martin Scheinin doesn't really require any special introduction, but I just remind the audience that he was a British Academy Global Professor at the Bonavero Institute from August 2020 to February 2025, where he led the project addressing the digital realm through the grammar of human rights law. He currently serves as a guest professor at Lund University in Sweden and a part-time professor at the European University Institute in Italy. And along his work on digital rights, Professor Scheinin has pursued a significant line of research on human rights and climate change, a perspective that we will look forward discussing today and learning more about. We are also very pleased to be joined by two knowledgeable discussants today. Lara Ibrahim is a DPhil law candidate at the University of Oxford. Her research focuses on public international law, particularly the extraterritorial human rights obligations of states in the context of environmental harm and climate change. And the last year, Lara served as a judicial fellow at the International Court of Justice, clerking for the vice president of the court, where she worked on a range of contentious and advisory proceedings. We're also fortunate to have with us today Danilo Garrido, who is a legal counsel at Greenpeace International, working on matters involving international courts and tribunals, fossil fuels, and biodiversity. Danilo is also a DPhil in law candidate at the University of Oxford, and before joining Greenpeace, Danilo worked in practice representing victims of corporate environmental harm and human rights abuses in various courts. Both Lara and Danilo are valued members of the Bonavero community, and we're very happy to have you today with us. A few housekeeping notes. We will begin with Professor Scheinin introducing the report, then we will follow with the reflections from our discussants, and then we'll open the floor for discussion and Q&A with the audience. So please ask your questions using the Q&A button. The webinar is recorded. So I think that's all for me. Thank you very much for everyone for being here, and I'll hand over to Professor Scheinin.
Thank you, Katya. Thank you for the introduction. I'm very pleased to engage this afternoon with the panel and with the audience in the important question of human rights obligations of states in respect of climate change. And as was mentioned by Katya, this event is intended to launch the publication in the Bonavero Report series of my expert report written at the request of the Republic of Vanuatu for the International Court of Justice proceedings in an advisory opinion case. And as most people know, the Bonavero Reports series is not a research working papers series, but rather papers related to public consultations and analogous processes, including opinions written for judicial proceedings or quasi-judicial proceedings. So I have prepared a couple of PowerPoint slides and I will share them with you. Just bear with me. Do you see my slides?
Yes, all works fine. Thank you.
Good. So what is perhaps special in the theme of today is that it is the question human rights obligations in relation to climate change. There are, of course, interstate obligations between states, and there's a body of international law called climate change law within the broader framework of international environmental law, which are often thought of. And then human rights have entered the picture in the sense that there's quite a lot of litigation at domestic courts or in international courts or regional human rights courts, which raises human rights arguments. One of the points I want to make, however, is that generally what we see at climate change litigation in the field of human rights is more about using human rights fora for pushing for the enforcement of climate change law, the emission targets of states, rather than looking at victims of human rights and how they are being affected by climate change and how states are failing one way or the other in respect of protecting human rights of those victims. And this is why I think today's theme is worthy of separate treatment. I refer to the questions posed to the International Court of Justice by the General Assembly. It's worthwhile mentioning here immediately at the outset that the Republic of Vanuatu, together with other Pacific Island states, were prime drivers of the General Assembly resolution and these questions posed to the ICJ. And that explains the focus on human rights instruments in addition to climate change law instruments, and also explains why there is so much emphasis not only on interstate obligations, but also states' obligations in relation to peoples, individuals of the present and future generations, as the last part of the second question spells out. So it is really an opportunity for the International Court of Justice to look into the issue of climate change, but even more broadly, the issue of obligations of states in relation not only to other states, but to peoples with a state or without a state, such as indigenous peoples, to individuals or groups of individuals who are personally affected by climate change, and then the question even of future generations. So this is an opportunity to operationalize within law, which usually is seen as a moral issue, ethical issue, rights of future generations. Can it be operationalized in international law, and can that be done by the International Court of Justice, is one of the questions. My report, published in the Bonavero Reports series as number 2 of 2025, was written for the ICJ proceedings, and verbatim, this Bonavero report reproduces, with the exception of some technical notes, the expert report written at the request by Vanuatu, which is Exhibit C in the ICJ proceedings. As mentioned, Vanuatu is not just one state among many who intervened, but really one of the drivers of the whole process. And this report, focusing on the human rights obligations, complements what I call the mainstream discourse on climate change law, which is about greenhouse gas emissions, the enforcement of the targets of states. And then the questions of the law of state responsibility, including in respect of extraterritorial harm and possible extraterritorial obligations of states. And having not read and listened to everything that happened in the ICJ, there are tens of thousands of pages, and there were 2 full weeks of hearings. I would contend that Vanuatu's submission, including my expert report, are not unique, but have a special emphasis on the actual questions posed by the General Assembly, which I just showed, and their references to peoples and future generations. While I was quite disappointed, I must say, listening to the government speak to the ICJ, who were so state-centered that they were really within the narrow frame of the international law of state responsibility, obligations of states in relation to other states, and many of them seeking to evade those obligations. I was surprised that, for instance, progressive countries, EU or EU member states or the UK, didn't really engage with the questions related to individuals, peoples, and future generations. One important source of inspiration for my report is the quite recent Human Rights Committee case, Danilo, Billy, and others versus Australia, which is a case by different Torres Strait Islander indigenous communities who are threatened by sea level rise, which already has greatly impacted both their economies, fishing is being depleted, and then there are other forms of culture, such as burial ground ceremonies, etc., which happen on those low-lying islands and are under threat of sea level rise. It's an important case because here the Human Rights Committee found violations by Australia of Article 17, privacy and family life and home, and 27, rights of minorities, including through interpretation, indigenous peoples as minorities in respect of a state party. So it was a successful human rights case concerning climate change. And in contrast to much of what we see as international and domestic climate change litigation, it was not focused on the question of states' obligation to mitigate climate change by reducing their greenhouse gas emissions. It was focused on climate change adaptation and Australia's positive human rights obligations to help the Torres Strait Islanders to adapt themselves to the circumstances of ongoing climate change so that their cultures would not be destroyed. And it was a successful case in this respect. There is a dimension which is related to the fact that Australia also is a major emitter. So that was not ignored by the Human Rights Committee, that there is also a causal link between Australia's emissions and the sea level rise, which we can observe globally and in the Torres Strait. Also, the Human Rights Committee did mention that Australia was quite aware of how sea level rise threatens the people's livelihoods and cultures of the Torres Strait Islanders. So there was a knowledge element as well involved. So I would say that the pertinent issue of state responsibility law were not ignored, but focus was on human rights. And then there's an individual dimension, there's a family dimension, there's a collective dimension as peoples, indigenous peoples. And I would say some of the major breakthroughs and contributions of this case are first, explicit recognition of transmission of a culture to new generations as a substantive element of the right to enjoy one's own culture. We all know ICCPR Article 27 has a provision on the right to enjoy one's own culture in community with other members of the group, but it doesn't explicitly say and to transmit it to the next generation, but it's in community with the group. There's Inter-American Court of Human Rights case law, where the idea of transmission of culture is very clear, but now it's also explicit and clear in UN level case law. This case has been followed already by the Committee on the Rights of the Child, Committee on Economic, Social, Cultural Rights, in other cases, and a brand new Human Rights Committee case related to the Maya in Guatemala also picks up the idea of transmission of culture as an important element of the right to enjoy culture. That was point one. And point two, where this is such an important case, is the operationalization of rights of future generations. Through this transmission argument, the Human Rights Committee extends the right to enjoy one's own culture, not only to transmit it to my children and grandchildren, but also to future generation. It's an element of the right to enjoy one's culture today, that one can think as a culture as something which is, yes, evolving, but nevertheless also continuing as something permanent. It's a contribution to humanity, richness of humanity, that typically indigenous peoples are able to pass on their culture and way of life to new generations and future generations. So that's one way to operationalize the rights of future generations. I need to mention that already in the Billy case, I was involved as author on an amicus brief, and I'm very pleased how the case then turned out at the Human Rights Committee and how it now can be relied upon in the ICJ case. I just quote the closing part of paragraph 8.14 of the Human Rights Committee, demonstrated with the arrow, that Australia had failed to take adequate adaptation measures to protect the author's collective ability to maintain their traditional way of life and to transmit to their children and future generations their culture and traditions and use of land and sea resources. This was the violation of Article 27 of the ICCPR, which to me answers many of the questions we are faced with in the context of how climate change affects indigenous peoples, other similarly situated groups with distinct forms of culture, and the rights of future generations. I close by simply contrasting the Human Rights Committee case, and I would say the framing of the ICJ case, with the European Court of Human Rights ruling on the Klimasenioringen versus Switzerland case, which is the other successful climate change case so far. They are quite different in the sense that the European Court of Human Rights case is focused on mitigation obligations of Switzerland. So it falls into the other category, the category of enforcing climate change law through human rights fora. And that's also the order of the remedy by the European Court of Human Rights, which is related to Switzerland's emission targets and how they need to be implemented. Both strands of litigation, of course, are needed and useful, but I think there should be more attention to the adaptation litigation, which takes climate change as a context, new kind of qualitatively different context for human rights violations, particularly where we have vulnerable groups such as indigenous peoples and similarly situated groups with a distinct culture which is threatened by ongoing climate change. So we can expect more of this in human rights fora, and I would hope that the ICJ picks up the theme in the sense that it will even at least try to answer those questions of the General Assembly that do not relate merely to interstate obligations, but also to obligations in respect of individual peoples and future generations. Thank you very much.
Thank you very much, Martin. Thank you very much for reminding us that actually the focus of the opinion was on those issues, the impact on the generations and the local communities. So departing from the heavy state-centered approach. As you've said, let's just hope that the International Court of Justice will delve into those issues. So now we will invite Lara as our first discussant to reflect and share her insights from the experience reviewing some of the state submissions in the International Court of Justice and reflecting on how they relate to human rights dimensions of climate change.
Thank you so much. And I'll start by congratulating Professor Scheinin on the publication of this report, and thanking the Bonavero Institute for inviting me to be a discussant on this, and to Katja and Danilo as well. So I just thought that I would spend some time situating this report in the context of the state submissions that we saw at the International Court of Justice. And just to kind of add on to what Martin has already elaborated on, this was the largest participation that we've seen in an advisory opinion by states. there were 91 written submissions and 98 oral submissions given by states in this advisory opinion. So it highlights just how important this opinion is. And something else to add on to that is, for the very first time, we saw a lot of states from the Global South participating in proceedings in the International Court of Justice, bringing fresh perspectives, especially on things like Indigenous rights, which the court has not really dealt with before. And I think that provided a very interesting perspective for the opinion as well. So I'll just share what I saw in the state submissions, both in the written submissions that they were submitted whilst I was at the court, so I was able to see that kind of first part of the proceeding. And then I watched the oral proceedings very closely in December as well. And what I picked up on was that human rights and climate change was a primary point of contention between states. And there seemed to be agreement amongst most states that either international human rights law is relevant in the context of climate change, that the obligations of states under international environmental law should be interpreted in light of international human rights law. And a lot of states in particular picked up on the preamble of the Paris Agreement, which references human rights obligations there. Or the majority of states where they had agreement here was that specific obligations exist in international human rights law relating to both the mitigation of and adaptation to climate change in relation to state obligations to respect, protect, and fulfill human rights, which is picked up on in the report as well. The states that argued that no obligations arose in international human rights law in relation to climate change are those states that Martin referred to, where they focused very much on the state-centered approach to the advisory opinion. And they included the United States of America, Canada, Australia, China, Saudi Arabia, and the UK. But even in the case of the UK, at least, there was a concession that individuals would be able to bring claims on the basis of human rights due to the impacts of climate change. And in their oral submissions, they actually began with the recognition that climate change impacts states and individuals disproportionately. But they did unfortunately go on to focus their submissions primarily on the obligations contained in the Paris Agreement, so the interstate obligations. And the states that argued that specific obligations existed in international human rights law focused on a variety of rights under both the ICCPR and the Covenant on Economic, Social, and Cultural Rights. States such as the Cook Islands argued that states have obligations to mitigate climate change in line with their extraterritorial human rights obligations. So even within this kind of subtopic of the advisory opinion, there was a broad range of discussion amongst states. So I'm going to focus the rest of my intervention on two key points that are raised in the report and by the state submissions to the ICJ, which is engagement with Indigenous rights and the question of intergenerational equity, and also focusing on the status of a right to a healthy environment in international law. So on Indigenous rights, as raised in the report, the Billy case at the Human Rights Committee clearly identified how climate change can violate Indigenous rights, and specifically within that instance, the right to one's own culture. And again, to reiterate how this includes a right to transmit a culture from one generation to the next. And on the whole, where states argued in their submissions, both written and oral, that human rights obligations existed in relation to climate change, they also acknowledged that the impacts of human rights violations were heightened for vulnerable communities such as Indigenous peoples. And what I picked up on was that this recognition wasn't necessarily limited to the small island states or states in the global south. We had Germany, Latvia, Liechtenstein, for example, all highlighting the differential impact of climate change on Indigenous roots. But of course, these states took different opinions on whether that translated into specific obligations arising in international human rights law in relation to these individuals. So to go through a few of the key submissions that I picked up on, Micronesia was one state that heavily emphasized collective rights in the context of climate change. They highlighted how climate change impacts cultural heritage and that states are obligated to take action that avoids interference with the enjoyment of indigenous peoples of their collective rights. Vanuatu, which benefited from this expert report, stressed again what Micronesia had said, but they also linked it to other rights, such as the right to life and the right to private life, and how this intersects with Indigenous rights as well. And in their written submissions, they argued that states owe heightened obligations to Indigenous peoples on the basis that the right to self-determination and cultural rights recognize, and I quote, make legally significant the distinctive relationship and close ties they have to their land and environment as the fundamental basis of their cultures, spiritual life, integrity, and economic survival. Other states, such as the Solomon Islands, highlighted how the displacement of Indigenous peoples and communities further violated their rights, and they argued that states potentially had obligations under the Refugee Convention for these persons. And powerfully in their oral submissions, the Cook Islands highlighted the racially disparate impacts of climate change, and that under the human rights treaties, states have obligations to prevent racial discrimination. So a lot for the court to consider in that context. And so moving to intergenerational equity, several states raised intergenerational equity in their discussions of human rights obligations in relation to climate change. I picked up on this rather than states actually raising the rights of future generations. And the states that did raise intergenerational equity invoked it as either a settled or a developing principle of general international law, which guides the interpretation and application of states' obligations in relation to climate change, rather than containing any obligations in and of itself. So, for example, Ecuador had argued that states must balance the interests of present and future generations when adopting and implementing measures to reduce greenhouse gas emissions. But as we see in Professor Scheinin's report, the Human Rights Committee in the Billy case has already laid the foundation for the operationalization of rights of future generations. So it was surprising to see not more engagement with this aspect as well. And just turning briefly to the right to a healthy environment. This was also an interesting debate amongst all of the state submissions, and it also formed the premise of Judge Orescu's question at the end of the oral submissions in December, where he asked what the legal content of this right was, as well as its relation to other human rights. And in the written and oral submissions, there seemed to be a majority of states, so around 50, that argued that the right to a healthy environment was a standalone right that had gained the status of customary international law, and that this right contains obligations to prevent, minimize, mitigate, and address the effects of anthropogenic greenhouse gas emissions on the climate system and the environment. And that other rights, such as the right to life, were dependent on the right to a healthy environment. But states diverged on what the content of this right was. For Barbados, the right to a healthy environment primarily encapsulated the prevention principle as it exists in international environmental law, so the obligation not to cause transboundary harm. And for other states, in particular the Pacific Island states, that right contains substantive and procedural elements, which includes access to environmental information and participation in environmental decision-making. And there were also different formulations of the right, so the right to a safe climate or the right to a healthy environment. And states such as Cameroon further argued that this right has actually reached the status of a peremptory norm of international law, meaning that states must cooperate to put to an end any serious breach of the norm. And a lot of states linked this right to Indigenous rights and intergenerational equity as well. So the Cook Islands again argued that this right is what provides heightened obligations for states in respect of Indigenous communities. So finally, kind of this all leads to the remaining question of how will the ICJ engage with these submissions? And I have a couple of points that I'd like to end on here, and perhaps end on a little bit cynically. So the first thing that I noted when I was at the court is that they very much use the oral submissions of states as a key indicator of what they should focus on in their final opinion. And although human rights obligations were a key aspect of the oral submissions, a lot of states, as has already been pointed out, decided to focus on the climate change regime and on interstate obligations instead. And perhaps the sheer breadth of the human rights question and the questions in general at the court will be a limitation in what they engage with. They have a lot to consider, and it's currently unclear what they'll choose to focus on. But following from that, it's clear that Indigenous rights and intergenerational equity really formed part of the key submissions of states that focused on human rights and climate change and the obligations therein. And this would be groundbreaking for the court to consider and to engage with. And finally, the recognition of a right to a healthy environment. I think the fact that a judge posed this question to the participants shows that we'll see engagement of the court with this question. But there'll probably be difficulties in defining what the content and parameters of this right is, which may mean that the court stops short of this. But I'll end there. And yeah, thank you again.
Thank you very much, Lara, and thank you for going into some of the nuanced discussion of the arguments. And it does look like the opinion could potentially cover a really diverse range of topics. We'll now hear from our second discussant, Danilo. And of course, Danilo, we're looking forward to hear some of your professional perspectives based on your work at Greenpeace and what the advisory opinion could potentially mean for civil society organizations and what its broader impact is.
All right. Thank you very much, Katia, for an invitation, to the Bonavero for hosting, and to also Professor Schein for the great report. So in my intervention, I'll divide it in two parts. First, what I call the participation paradox, and then I'll go on some key insights from Professor Scheining's report that I think could be useful for litigators and civil society in general. So on the first part, I always whenever talking about this case, I like to bring it back to its earlier roots. So this AO process, it was originated within civil society. The very beginning of it was a group of students from the Pacific that were tasked by their professor of international environmental law to come up with legal strategies to mainstream climate change in international law. And the idea to bring an advisory opinion was actually one of the products of this class. And then the students started organizing and lobbying their own governments to actually make this a possibility. So they had a very, prominent supporter in the Vanuatu government who took it all the way up to the General Assembly, and through many negotiations of the text, were able to approve unanimously a General Assembly resolution asking for this advisory opinion. So this is a case that's very meaningful for civil society, and we are engaging very much with it. And the paradox comes that when it came to the actual proceedings, civil society was not allowed to participate because of the procedural rules of the court. Or should rather say, a certain interpretation of the procedural rules of the court, because in the past there has been a case where, in the Southwest Africa advisory opinion, where the court did allow civil society organization to participate, the League of the Rights of Man, but they have abandoned that position recently. But civil society still managed to be part of these proceedings through different ways. One of them was by sending briefs or amicus, nonetheless, to the court, knowing that they would not be part of the proceedings, but still would be available for the judges to consult if they so wished. Another point, which was a positive surprise in this proceedings, was a number of states and international organizations actually yielded part of their time before the court, which was for most states only 30 minutes, to civil society representatives. Some of those being Vanuatu inclusively, others being the Netherlands and SPC. So states were able to hear from the frontline defenders about the climate change impacts that they were experiencing in their work and give that human element that we saw being very effective in getting a progressive decision from the court previously, for instance, in the Chagos advisory opinion, where they also had a statement from impacted communities there. And outside of the court as well, during the whole 2 weeks of the proceeding, civil society did a lot of initiatives to keep raising the profile and the attention around this, which included People's Assembly that actually produced a report at the end that was then cited during the proceedings on the final day within the court. So a very interesting dynamic between outside of court and inside of court proceedings. There was a People Museum, candlelight vigil, peaceful protests, several different initiatives around to show that civil society was paying attention to this. The reason being, this being the main judicial body of the United Nations and the decisions of the court carrying so much weight in international law, we believe that this could be instrumental for future not only advocacy work within states, but also litigation, whether interstate or intrastate human rights litigation, which then connects me to the second part of my my intervention, in which I would like to call attention to to 3 points from Professor Scheining's report that I think could be very useful for climate litigators, and especially those paying attention to human rights. The first one is on diagonal disputes, so disputes between individuals from one state versus a foreign state. Professor Scheinin highlights the importance of self-determination in his report, that being an erga omnes obligation, meaning that, and here I quote him, peoples are entitled to invoke that right in respect of the state where they live, or in respect of other states or the international community as a whole. This is something that's being tried already in some litigation. Recently, we had a loss on this point in the Duarte Agostinho case before the European Court of Human Rights because of the jurisdictional challenges of this. But in that case, the erga omnes element was not really argued. So I do think that reframing and rethinking it in terms of what are the erga omnes obligations that we can connect to climate change could be an interesting angle for future diagonal disputes in relation to climate change. A second point that I would highlight is Professor Scheining's argument that the protection afforded to indigenous communities in various international instruments could be extended to the entire population of island states. As he explains, what matters for those obligations is not the criterion of being the first in a certain land or territory, but actually the situation of particular vulnerability to climate change of a people of community with a distinct way of life based on the natural resources of a particular geographical area. This again opens up possibilities also for interstate disputes in relation to these rights, with island states acting as custodians of the human rights of its own inhabitants that are being harmed by the actions of other states, as Professor Scheinin highlighted already in his report. And the final point that I would like to raise is on collective action. Professor Scheining's submission to the court was made prior to the Clima-Sionurinen decision by the European Court of Human Rights, which is why I think the Bonavero report is a great addition, because he was then able to address it in the preamble of his report, and also reflect on the relevance of this climate case to the questions put before the General Assembly. So a key aspect of the Senorina decision is the finding of the court that civil society organizations might actually be a more adequate claimant than individuals when asking for more climate ambition from states on the mitigation cases that Professor Scheinin was mentioning. This ties in very well with what was in the report that which emphasize the impacts that climate change have on the collective, as also the excerpts from the Torres Strait case that Professor Scheinin highlighted in his presentation make clear. And also the impacts on vulnerable groups that I mentioned on my previous point. So in that case, the European Court found that senior women were particularly vulnerable to heat waves that were made more severe due to climate change because of their age and gender, which again stressed the point that Professor Scheinin was making on the importance of the situation of particular vulnerability to climate change for individuals when bringing disputes. So I'll leave my interventions at that, but also congratulating on the great report once again. Thank you.